You raise your hand at the same time. Is it
I was
Gatito?
answering a question. Sorry.
Yeah, there was someone before you. Or anyway, you can raise your hand again. We go. Anyone else?
Yeah,
Yes.
it was me, Gitiko. So I wanted clarification on summary judgment under Order 36 and judgment in default under Order 10 Rule 4, because I'm getting confused between the two.
You are saying some summary judgment,
Yeah, and judgment in default.
default judgment, and or
Yeah,
those two.
so I wanted the distinction between those two and when you can seek for either
Okay.
summary judgment or judgment in default.
All right. All right. Thank you. Thank you for the question. Lim Lim, maybe you can take this one. Lim Lim, are you there? Yes, Denver.
May I try to answer that question?
Yes, please.
So this is my best understanding. When a party brings a suit before court, the defendant has to enter appearance, and they do so through a memorandum of appearance and filing of a statement of defense. So now, when the party does not enter appearance, either through the memorandum of appearance and statement of defense, then you can move to court to ask for judgment in default. So it's normally judgment in default of entering appearance. That means the other party has not entered into appearance. So you can move to court for that. And in some instances, the court can give the judgment of its own motion. Now, a summary judgment occurs when the other party, yes, if they do enter into appearance and they do file their statement of defense, but you argue that there are no triable issues in their statement of defense, in terms of there's nothing that they are raising that raises maybe a question of law or a question of fact. So in that event, you apply for summary judgment, and then the court will weigh their statement of defense against your application, and then they can give you summary judgment. Yeah.
Okay. Okay. Thank you. Thank you very much. Anyone else? Anyone else who has something to add? Yes, Mihango.
So probably to add on what he has said, in the case of a summary judgment, now, especially when you're making the application under Order 36, where it talks about summary judgment. So you can make an application after a party has entered appearance. You can make an application for a summary judgment before that party files a defense. It does not necessarily mean that you can make that application after that person has filed their defense. You can also make an application for a summary judgment just before that person files their defense. Now, the main but now you are from your pleadings and the evidence that you have adduced, it must be clear that even if this particular person files their defense, there will be no triable issues that they can raise, because now whatever case you're presenting before the court, it speaks out for itself. That is all I can add.
Well answered. Well answered. Well answered. I don't know if I have something to add on that. But Daniel, can you comment?
Angelo,
Yes, sir.
it's just a few minutes. I'm looking for something. I think I'll just get it soon. I just wanted to be very sure when we are answering that question, because I feel like it's a question that is always asked. So for Summary judgment. Sorry, I still have my notes. Must be for a liquidated claim. Suit must be brought by a plaintiff. Defense does not raise any tribal issues. Is for recovery of land without or with mercenary profits. Yeah. So I think as much as I was really thinking about that. I felt like there's more there's more to add. So for both default judgment, and I want to agree with what everyone has said, I just want to add more. So for default judgment, we are saying that this person has not filed appearance, they've not filed any defense, they're just there, they've not done anything. Then now you go forward and make an application for judgment in default of appearance. Okay. And should be for liquidated claim. Again, it's very important that one thing that I've realized with orals is if you get a question that is very easy and you're able to answer everything, do not leave anything out. Cut that cake and eat it fully. Say every single thing. Don't have the lecturer asking you, what are the elements? And what about, because the main reason as to why sometimes we have orals is they want to know if at all one day you are in court and you're supposed to present on these two things, you want to differentiate these two things. Will you do it fully? Will you make the court understand everything adequately? So for both of them, they have to be for liquidated claims. So for default judgment, what we're talking about is there's no defense, nor an appearance. For summary judgment, again, it must be for, and I think at one point someone will explain to us when we say liquidated claim, what do we mean? Because again, it's a question that could be asked during orals. Oh, you said liquidated claim, but what is a liquidated claim? What is the difference? Why are you insisting it's a liquidated claim? So we have both of them are for liquidated claims. Then for summary judgment, we've said for default judgment, there's no defense, nor appearance. No one is doing anything, but yet you filed. Happens a lot in small claims courts. Then, so for summary judgment, we've said one thing that they share is they're both for, it must be for liquidated claim. Then suit is brought by a plaintiff. Then that's summary judgment. Then defense does not raise any tribal issues. Then it's for recovery of, where it is for recovery of land, it must be for land without it's for recovery of land without or with mercenary profits. I know we know that what that means. Yeah. So you please try as much as possible to ensure that you talk about the fact that it's for liquidated damages, liquidated claim. Talk about the fact that when in default judgment, we're talking about no defense, no appearance. Then on this side, ensure that you talk about, summary judgment is brought by a plaintiff, then defense does not raise any tribal issues. I think this is one thing that all of us have said. Just that I'm just adding this because I feel like we've only talked about no tribal issues. The other side, no defense. There are more that you can add to it and you'll get more marks. That's all. That's all I wanted to add. Thanks.
All right. Thank you, Daniel, for that. What was your name again? Maybe if you have a follow-up question or if you have a question.
No, I'm okay. It has been answered.
All right. Thank you, Gitito. Asante sana. Aya. Na mko na majina ngumu. Maybe you can unmute with Atitio. Okay, anyway, Tio something. Ebu, please unmute. And
Yes,
away.
I wanted to give a try on the question asked on the liquidated damages. So the liquidated are where specific figures have been given. For example, if it's 10 million, it's directly stated as 10 million.
Okay, thank you. Thank you very much. A liquidated demand is something that is capable of calculation, and let's say a specific sum. That is a wonderful contribution. My Inji Muridi, please unmute.
I hope I am audible.
Yes, you are audible, sir.
Yeah, mine was okay. I above a contribution with regard to default judgment under Order 10. We have kind of left the interlocutory Okay, yeah, the interlocutory judgment part, whereby we have the unliquidated now damages part leading to the formal proof. So I don't know whether that kind of still applies when you're asked about the default judgment.
Yes, that is a good question. You see, if it is not liquidated, if the claim is not liquidated, maybe the judgment was entered in default. So there is always something called formal proof hearing that will happen thereafter. Okay. So the first step is for the judgment to be entered in the follow appearance, and thereafter a date is going to be fixed for formal proof hearing, such that now it can be, let's say, ascertain what the figures are. For example, if it is an RTA matter, so maybe you have served the defendant for one reason or the other, maybe they have you have served them, they have failed to enter appearance. You can tell court that. Court will tell you again to reserve. You do that, then you come. So once you come, you will make your application, whereby you will ask for judgment to be entered against the defendant. So on that day, the judgment will be entered, but now another date is going to be fixed. So if it was liquidated claim there and then, you will have your the figures that are already stated. So it will be easier that. So I don't know if I'm making sense, Maingi.
Yeah. So a follow-up, then can that be kind of a difference between a default judgment and a summary judgment? In that a default judgment, it may be applied in both instances where you have liquidated damages and unliquidated damages, whereas summary judgment is specifically liquidated damages. Because for the default judgment, we will now have the default interlocutory judgment under Order 10 Rule 6.
I think I agree with you. Then Daniel, what do you think?
If you ask me, I tend to differentiate these three judgments. If you ask me, I usually have three. I have summary judgment, I have default judgment, then I have interlocutory. And even when you are in court, when you make an application, the court will always ask you, do you mean default judgment or do you mean interlocutory judgment? And every time you ask that question is because of the claims that you have at hand. If you ask me, I believe that for just default only, without adding the interlocutory that you're talking about, it is liquidated claims, same to summary. But interlocutory, then that can cover the unliquidated claims. That would be my answer. I tend to have those three. I don't say default judgment and default interlocutory judgment. I tend to separate those three so that I have, it's easier to explain my thoughts. I tend to do that. It makes it easier to understand for me and to answer the questions.
Daniel, excuse me once again. You are saying that you do differentiate between summary judgment, interlocutory, default judgment, and default judgment, or I have not heard you correct?
Yes, I tend to put them separately.
Mm-hmm.
Yeah, so that it's easier to explain and to understand. And whenever I make an application to court, I know what to say exactly. Because when you say default and it is interlocutory, then the court will ask you, do you really know what you're talking about? But when you say default and it is liquidated claim, it's easier. But when you say interlocutory and it is unliquidated, it's easier. The court will easily understand what you're talking about. But when you mix the two, it becomes a bit of a problem. So if you want, yes, since it's under the same order, you can clump the two together and explain. Okay, I personally have no problem with that. I tend to separate them so that it's easier for me.
All right. Okay. Thank you. Thank you for that. Maingi?
Thank you, Daniel. For those of us in Class C, and I believe Denver is together with me, Miss Mongare, I hope I'm not getting this wrong. She kind of introduced a default interlocutory judgment, and I'm kind of having an issue getting the difference between the default interlocutory judgment that she introduced. But I kind of incline with Daniel's understanding and separation of the same. But I still stand guided and will do further research. Thank you.
Okay, thank you. Denver?
I also tend to agree with Maingi to the extent that we were taught, as per the rules, you can enter an interlocutory judgment in default of appearance. I think in practice, what Daniel is saying is accurate in terms of differentiating, because you will be asked, what are you exactly applying for? But I think as per the rules, the interlocutory judgment still applies, yeah, in default.
Very good. So we have we have a lot of work to do in that regard. Anyway, I had somewhere that I had written them, especially specifically for purposes of oral exams, because most of the time you'll be asked to give the differences between the two. But now you realize most of the people will just go to the definitive part on what one thing is and what the other is. But you see what Daniel said before is just exhaust it, okay? Because I know when I was preparing for my orals, I was having at least 3 or 4 differences between the summary judgment and default judgment. To that extent, if you can exhaust them, I can assure you can get maximum marks. So what I'm trying to say is, please don't limit yourself unless now if you are forgotten, okay? Because there are some lecturers, I don't know why they don't really like people. I don't want to mention their name now that the meeting is being recorded, but she teaches in class G, okay? She teaches in class G. She had a vision of becoming a high court judge. But please be very, very, very careful. If you have an avenue of exhausting, it seems simple, but that is where now they expect a lot from you. So when you know that a question is simple or it appears simple to you, then please try to exhaust. Do more, do more. They expect much from you. That is what I can say. Daniel? Odor, are you there?
That's it, yeah. I have nothing to add.
Okay, thank you. Another person? Yes, we are doing well, guys. Anyone else? Please raise up your hand.
And Angelo, it can even be general questions. It doesn't have to be
Yes.
substantial.
Thank you. Yeah,
Yeah.
this one is not limited to content. It's not limited to content. It can be anything. It can be anything. Yes. Leonora.
Good evening.
Good evening.
Can you hear me?
Have I pronounced your names right?
Yes, it's Leonora.
All right.
So I have a little issue. I usually can't. I have a problem differentiating between a counterclaim and a set off. I think they confuse me. If you could at least elaborate and expound more on that, I'd really appreciate it.
Okay. Thank you for that question. Lim, are you still in?
Yes, Angelo, I'm still in.
Okay. Please highlight, then we will have Denver.
Okay. Now, when it comes to a counterclaim, let me use the examples now. Okay. You are the plaintiff, and you have an issue, especially when it comes to the question of seeking a debt. For example, you want to get a debt, your debt being settled by the defendant. Then now when you go to court and you serve the person, the defendant, then the defendant will acknowledge, after acknowledging that there is an issue on a particular amount. Let me use the example just to make it a bit easy. Let's say you are claiming that the defendants owes you 1 million. And then now the defendants will say, well, it is true, I owe the person 1 million, but the other person also owes me, this person, the plaintiff, owes me, let's say, probably 2 million, something like that. So you will counterclaim, you know, you have claimed that this person owes you this, and then the other person acknowledges that, but also launches another complaint against you that you have done something wrong against him or her. Okay, you are the plaintiff, and the person you are suing is the defendant. You are claiming that he has done this, and the same person, while responding to your plaint, he will now kind of launch his complaints against you. So that is what is called a counterclaim. It is how can I put it? It is an issue that has been raised by the defendant. In addition to the issues that you have raised against the defendant, he or she raises an issue in the response to your plaint, or I think, I'm not sure whether it happens to the petitions also, that there can be a counter petition. So he raises an issue against you as well. That becomes now a counterclaim. If it is a claim, you have claimed on this, he accepts, and then he brings another claims against you. I don't know whether I'm making some sense in that regard. But when you talk of a set-off is a case of, let me use the same amount. This person is talking of you having a debt of 1 million. And then now you'll accept and say, yes, I have a debt of 1 million. But the same person owes me 200,000 shillings. So now the court, what you are saying is that this person having owed you 200 million. So in other words, you want that 200 million to be deducted from the 1 million. Then the 200 million becomes now a set of, you are offsetting 200 million from the actual claim. I mean, not 200 million, 200,000 from the actual claim of 1 million. So what the court will say, now you have to pay the person will be the 800 shillings as opposed to the 1 million that is claiming. So what becomes the sort of, in the way I understand is, it is the 200 shillings that you owed the plaintiff. I don't know whether I'm making sense. That's the simplest way I appreciate it. Who asked that question? And I think, Angelo, you can add, or Daniel can add on what I have said. Thanks.
All right, thank you, Lim. That was really nice. That was really great. Denver, you wanted to say something?
Yes, I did. So as it was explained to us, a counterclaim acts as a sword, whereas a set-off acts as a shield. So in a counterclaim, what you're doing is you're basically instituting a separate suit against the person. So in practice, it would be somebody has sued me, let's say for 1 million, for example, but I feel like now maybe for the delivery of goods. I delivered some goods to them worth 1 million, and so they're with them, and I haven't yet paid them. But previously, I had loaned this person, let's say 1.5 million actually, for maybe a separate thing. Maybe they wanted to construct their house or something of the sort. So what I'm doing is I'm counterclaiming. I'm asking for, while I'm saying I actually don't owe this person this amount of money, what I'm saying is this person is the one who in actual effect owes me money for this particular situation. So it's a sword, because now you see the difference comes in, whereby now a set off is where you're saying, yes, I admit that I do owe this person money. Let's say it's the 1 million, but in reality, I had actually settled 500,000 with them. So I'm shielding myself against the total amount, whereby in the other one, I'm actually asking for them to pay me a certain amount. So in practice, how this works is a counterclaim can continue even after judgment has been made on the main suit. So whatever it is, whatever suit it is they instituted against me, after it is finished and judgment has been passed, the counterclaim can still continue as a separate motion. Whereas in the case of a set-off, the set-off ends where the suit ends. So whatever judgment is given, the set-off is finished at that point. So that is the difference. One acts as a shield. That is, you're shielding yourself from the total amount that they're saying you owe them by saying, I accept that I owe them money, but this is not the amount of money that I owe them. But in this other one, you're saying this person actually, I don't accept this debt, and actually I'm saying this person actually is the one who owes me money. So that's the difference as per my understanding.
Okay, that is well explained. Leonora,
Yes. Thank you
Mhm.
for explaining it. I understood it better. Thank you.
Very well. So what you can do, there are majorly two differences that you can take. The first one being that a set-off is in the nature of a defense, that is a shield, whereas a counterclaim is in the nature of a cross action, into bracket sword. Okay, so you can actually institute a separate suit if need be, or you can raise it in that similar claim. I don't want to belabor the point much because it has been explained. The second main distinction, because most of the time you'll be asked to give the differences between the two, whereby you will have to define them, then you proceed to distinguish them, or what you think are the differences between the two. So finally, what I can say is, under a set-off, the defendant cannot recover anything against the plaintiff, for he can only use the set-off as a defense or answer to plaintiff's claim equal to the amount of the set-off. So a plaintiff cannot therefore obtain security for costs in respect of a set-off. While on the other hand, now you see you can actually seek for costs, that is on the aspect of a counterclaim. Okay. Yes, Gititu, your hand is up.
Yeah, while we are on the subject of counterclaims, I had a question. Are counterclaims similar to cross claims?
Okay, thank you for the question. Daniel Odur.
Yeah. You're calling me, Ama, you change your mind.
No. Our colleague is asking whether counterclaim are the same as cross-claim.
Okay, for us, I think we used to write counterclaim stroke cross-claim. I don't think there's a difference unless there is. Maybe Angelo, maybe you can tell us the answer.
No, I have the same view. What I know in the jurisdiction we are in currently, we talk about counterclaims. Most of the times, for example, in petition we have cross petitions and stuff like that. Gititu, I don't know if we have answered you.
Yeah, it's okay.
Very well, thank you. Yes, Maingi?
Okay, if I may try answering Gititu, my understanding is that A cross-claim is a claim that is either brought by a plaintiff against a co-plaintiff or a defendant against a co-defendant within the same suit.
Yes, yes. And therefore, it will mean that then counterclaim and cross-claim are different thing. And that is why I pointed out that here we talk most of the time about counterclaim, and indeed a cross-claim is a claim brought by a plaintiff against a co-plaintiff, and or by a defendant against a co-defendant. I don't know why I have not have sight of this in our civil procedure. Daniel, I know you are in corporate doing a lot of conveyancing.
Just a minute, Angelo. Kindly allow me to interrupt you.
Yes,
Order
please.
22 of the CPR, it provides for cross decrees and cross claims in mortgage. So provisions of rules 14 and 15 shall apply when one or both of the decrees for sale. Okay, that is the only provision that we have on cross claims in the CPR.
Oh, or are our plaintiffs and defendants most of the time they think they cannot sue each other or something? All right. Thank you for that. Who was it? Maingi? You are the one who asked the question, or you are the one who answered the question?
It was Gititu, and I answered, and I had a follow-up question so that I close this.
Yes.
To limit the explanation of a counterclaim. I was asked, are there really any admissions in counterclaim whereby the defendant in lodging the counterclaim accepts or admits liability? Because from my understanding is that a counterclaim, being a sword and a shield, is that you say that no, I do not owe this person any amount of money, instead it is this person who owes me. Because from my understanding, the moment you admit that yes, I owe this person an amount of money, and he on the other hand owes me this amount of money, it kind of amounts to a set-off. So maybe that can be clarified, but that is all from me. Thank you.
All right, that is a good question. You see, for counterclaim, you are actually raising a cause of action. Okay? And since it is a cause of action, it will be, let's say, if you maybe admit to that particular cause of action, so you know judgment is going to be entered on admission. Okay? Judgment is going to be entered on admission. So it is not that easy, like, for example, if it is a set-off, because if you raise a set-off, maybe the amount is similar, or maybe the amount is half or a three-quarter of what is being claimed. So it's, you know, the amount that you have raised in your set-off, that is what will be crossed out. But if there is a balance, then that is what you will pay. Okay? But if you raise a counterclaim, you are actually raising a separate cause of action. You can go and file a different suit, or if you see sometimes these things are costly. So because of convenience or something like that, then you raise your counterclaim, and the person is going to respond or reply to your counterclaim, and maybe he admitted to that particular counterclaim, then judgment is going to be entered against you on admission. Yeah, I don't know, but that is how I view it. Maybe Daniel Odor, you can highlight.
Someone just asked me a few minutes ago that what of set off and set up? What is the difference between the two? What does it mean when you say set off, and what does it mean when you say set up? Then I think I've also heard someone saying that when it's a set off, then when the court is making a decision, then the court will make a decision for everything. But for a counterclaim, the other decision of the counterclaim can be made separately. I think there's so many questions on this particular topic. Maybe we can take our time and read through Order 7, Rule 3. I think that's where I can see we have a defense, we have setup and counterclaim in a defense, and we'll be able to answer all these questions. However, just to answer the question that you've asked, I believe that maybe it would be simple to say a counterclaim is a sword and a set-off is a defense. In a set-off, you are saying that, this person is saying that I owe them this amount of money, but they also owe me this amount of money. You're protecting yourself. However, in a set-off, it must be that the amount of money that you are saying that you are owed by this person could be the same. Angelo could have sued me for 1 million, and I'm saying Angelo owes me 1 million anyway. So those two amounts should clear out so that nobody owes anyone anything. So I've defended myself. In a counterclaim, I can decide to file a defense and also file a counterclaim where I'm saying, yeah, Angelo is saying that, I owe him 1 million, but I don't even owe him anything at all. In fact, Angelo owes me 2 million. The same thing Lim has said. I don't think there's a problem if you agree and you counterclaim. I don't think there will be a problem. However, one simple thing that I know is that, and the way someone explained here clearly, in a counterclaim, it's a sword. You are attacking anyway. You are saying that, oh, I'm counterclaiming. There's this amount of money. But in a set of, you're saying that, oh, it's 1 million. Okay, he owes me 500,000 anyway. So that should be subtracted when you're making a decision. Oh, it's 1 million. Well, I gave him goods for 900,000 the other day. So yes, maybe I owe him 1 million, but let the 900,000 be subtracted when I'm paying him the 1 million. So I think maybe that would explain it more easily. And maybe we can all take our time and maybe just read through Order 7, Rule 1. But I think for me, what is very simple is set off. Just think about defending yourself. It's a shield, and counterclaim is where you're attacking this person. So you can defend and say no. In fact, he owes me this, or whatever you decide to do. But in a counterclaim, you are asking for something more than whatever you've been sued for, or it could be the same, but you're also defending and saying that actually I don't owe this person anything. Yeah, that's all I can add, Angelo.
Okay, thank you very much. I believe it is clearly controversial, but please look at. Let us go and read more. The orals are around the corner, but we can move on from it at this juncture. So maybe anyone else who has a question, it can maybe academics or in relation to oral exams. Not necessarily on the content aspect, but you can ask any other question that is relating to the oral examinations. Anyone else? Yes, Wekesa K. Please unmute.
Yes, so I have this issue in conveyancing. I would like to know what is a cadastral map, and also there is also another map. I cannot seem to recall that name, and how they are used in practice.
Okay, thank you for the question, Wekesa. Daniel Odor, this used to be your former.
Okay. I saw you asking me that. Like I'm having a dream. Yeah, maybe it would be very simple. Just the person who has asked the question, if you just Google maybe the meaning of cadastral and what it means, it's a map really. So a cadastre or it's cadastre is a comprehensive recording of the real estate or real properties, meters, and bounds of a country. Often it is represented graphically in a cadastral map. So basically, it's just the real the real boundaries in a map. For example, someone gives you a map of Kilimani and shows what are the real boundaries within which that property exists. For example, you'll see the boundaries goes until close to Kilimani police station, then up to 4 Point, then down to, this particular place and this. So basically just gives you the physical boundaries or the physical geography of that particular property. So it's basically just a map. It will just show you, where the boundaries are on paper, in comparison to other properties that are surrounding that particular area. I believe that is how simple I would explain what that cadastral map is. But it's always easy to just, if you look through them when they're submitted to you, can always just see. It's nothing complicated really. And I don't think anyone will ever ask you what that is. But yeah, simply it shows you the geographical boundaries of that particular property.
Okay, thank you, Odor. I have interacted with a few transactions, and the person that is in charge of conveyancing where I work, it is one of the things that we ask for. Where is this one? Where is this one? And it is among the documents that we received. So for me, I have never taken interest in conveyancing, because it showed me that some time back, and we are not friends. But yes, Wekesa, is that okay?
That is okay.
All right, thank you, sir. Please don't worry. It showed me that it did not show Dordas or maybe Limlim. Okay, I did not fail it, but I gave it my all. But it was the least scored marks in my transcript when I gave it my all. I have a grudge against conveyancing, but yes, it is enjoyable.
Angelo, there was no quid pro quo.
No, it wasn't. But I really feel bad.
Sorry, it's life.
Yeah. All right. Thank you, Ekesa. Anyone else who has a question? That we can move faster. We let you go. Yes. So, I don't know why your names are hard today. Okay, Japheth, please unmute.
Yes. Good evening.
Good evening, sir.
Okay. Would you please explain, because something seems not to be clear unto me, companies limited by guarantees and companies limited by shares. Just elaborate with that.
Okay, thank you for that.
You don't have to call. You don't have to call me. Let me just answer.
Okay.
I knew you're gonna be a doer. Anyway, yeah. So I think I'd like to make it as simple as possible. Company limited by guarantee and company limited by shares. So I think maybe just think about it as a layperson. Let's leave out the jargon and the way sometimes lawyers want to make things complicated. So let's say, for me, I'm limited by my name. Like, you can only call me Daniel or Daniel Stephen Oduro. You can't call me anything else. And for Angelo is limited by his blood. The blood is I am not sure, but it's the type of his blood is B positive. So if you want to define him, then you use his blood. So basically, the reason why I've said that is it's a company, yeah. Just that the way they're limited is it's just what limits them that is different. So a company that is limited by shares is, the liability of those particular persons. If anything happens, the liability are limited to the shares that these particular persons hold in that particular company, the unpaid shares that they hold in that particular companies. But when you talk about company limited by guarantee, this is where we have a document in our articles of association, and Angelo is saying that yes, I own this company, but in the event that anything happens in liquidation or anything else, I'm writing it down right here. This is the amount that I guarantee to pay in the event of liquidation. Only this. I'm only guaranteeing to pay 500 million and nothing more. So it's not about the amount of, it's not about shares. Oh, Angelo has shares. In a company limited by guarantee, there are no shares. So it's not about, Angelo has this amount of shares, and if the company goes down, then Angelo is supposed to pay this up to this particular amount of unpaid shares. Okay. So it's that simple. In a company limited by guarantee, it's if anything goes wrong, if we have liquidation, the only amount that Angelo will pay in that particular company is the amount that Angelo wrote down, the guarantee that Angelo gave the whole world, that if anything happens, this is the amount of money that I'm willing to pay to offset any debts whatsoever that could be existing. This is how much I'm guaranteeing this particular company. So you could call Angelo a guarantor, whatever you want to call him. But if anything goes wrong, Angelo will pay to that particular amount that he has, when the company was established, that he wrote down that he would pay in the event that anything goes wrong and that company is being liquidated, and there are people who are owed this X amount of money. Okay, so that is guarantee. Angelo is a guarantor. He guaranteed he'll pay this amount of money. That amount is written, that amount is known. But for a company limited by shares, I know there are other things that you can go into and say. But I just want to give you the easiest way possible to just move on with life. So company limited by shares is, I am liable to the amount unpaid on my shares. But you see, now I'm talking about shares. I'm not talking about guarantees here. I'm not talking about me sitting down, writing a document and saying that if this company goes down, I'll pay this amount of money. The amount of money that I'll pay if the company goes down, there's liquidation and we have debtors, coming for us, the amount that I'll pay is limited. What we look at is the shares that I own, and we will look at the unpaid shares. It's limited to the unpaid shares that I have and nothing else. Here we're not talking about guarantee. I'm not a guarantor or anything else. You'll only look for the unpaid shares, the amount of unpaid shares that I have, and that is the amount that I'll pay. Nothing more than that. So basically, it's just semantics. Really. Sometimes we try to confuse, but basically it's just semantics. But of course, there are other things that you can talk about when you talk about a company limited by guarantee and a company limited by share. For example, if you have a company limited by guarantee, you'll be told most of the time it's for charity, NGOs, and all these other things. But then for a company limited by shares, it's for companies that are for purposes of making profits. People are actually like Safaricom, for example, like Airtel, where you are setting up a business for purposes of making profits. There are other differences that Angelo can elucidate on.
Daniel Odur, you are muted.
I said the other differences that maybe you can explain about. I know the other differences, apart from the fact that, we have shares, the other side, we have guarantors. Of course, the articles state that limitation is as to the unpaid shares. The other side, the articles state that limitation is as to the amount that has been guaranteed. Angelo, are there any other differences that maybe you want to add?
Yeah, there are no much. Maybe I can have Lim. This should be fresh in your mind. They are basically about 4 differences or 3. Lim. You see, one being the certificate of incorporation, of course, will indicate that it is a company limited by guarantee, and the other one will say that it is a company limited by shares. Actually, those are real differences.
They're quite simple. But most importantly, the person who asked the question, do you understand the difference and how easy it is to know the difference?
Yes, I got that very clear.
Oh, all right, thank you. So it is just that when someone will ask you about the differences, you just pick, let's say, the ones that will come in your mind easily, okay, because there is no much difference. So the other one is of course limited by shares, and then you just juggle in between, and I know you can get your bearing when someone asks you that.
Angelo, I have a follow-up question,
Yes.
maybe to the class. Can a public company be limited by guarantee?
Actually, I was asked that question in one of my pupillage interview. And anyone? That is a very good question, guys. Anyone?
Please repeat the question.
Can a public company be limited by guarantee? And if no, what's the rationale?
Yes, Tito. Please unmute.
Yeah, I would like to attempt, and I would say that it cannot be limited by guarantee because public companies, they are governed by the Capital Markets Authority, so they have to be limited by shares because that is how you subscribe to become a member of the public company.
Okay, thank you. Thank you for that. Yes, Daniel.
Well, makes sense. Since public companies, they have IPOs, people have to buy shares and everything else. That's why, and they are limited by, they are regulated by the capital markets, meaning you have to have shares because in the capital markets, what people sell there is shares. So if you're limited by guarantee, then what are you selling at the NSC? You know, you must be able to. There, people sell and buy shares. So yeah, I agree with my friend that for public companies, then they have to. Yeah, but I think there are other things. Yes, that is okay. It makes so much sense. But the other day I was just thinking about it. What if we had these public companies where someone will tell you, because in a public company, the exposure is quite huge and the public interest is at a high, is at a high, and the risks of default and everything else is quite high. Anything could happen. Yet the government also has to protect the company. Apart from the fact that, yes, you cannot sell what you do not have. How would you be in the NSC if you don't have shares? I'm just thinking if one day Angelo, okay, of course, Angelo is a good guy, yeah, but a guy called Angelo starts a company and tells people that I have this company and we have gold. We've just realized that we have so much gold that we're digging in this particular area. And in fact, in this company, my guarantee is 500 million. Then Angelo goes public with that, and people just start becoming members of this company. Then one day things go wrong, or one day people just start dealing with this company in one way or another. Then at the end of the day, you realize that Angelo Kumbe, he said 500 million and Angelo does not even have any money whatsoever and he's not able to pay. Then so many people would be in trouble. But yeah, I was just thinking about that. So then at least shares, yeah, at least. And it will be shared by so many people. It can't just be Angelo saying he has 500, which do not even actually exist. So yeah, so I was just thinking that to protect the public interest and for risk, I was just thinking, but yeah, the answer that has been given, I think, is quite clear. You can't trade what you don't have. You don't have shares anyway. So how do you even go public? Yeah, that's all.
Okay. Thank you. Thank you for that, Odor. So for our friend, is it Jafet? Please go and look at sections 4 of the Companies Act, such that you can get the differences in terms of definitions between company limited by guarantee and a company limited by shares. So from there, you can actually take down a few notes and you will be good to go. Yes, Daniel Stevens, or is it Daniel Odor? We have Daniel Stevens.
Anyway, I wanted to ask, okay, one question that also is always being asked during orals is what is corporate personality? Maybe someone can also answer that just to remind people. I've seen it a lot. What is corporate personality? You could be asked that question. What would be your answer? What's corporate personality?
All right. Thank you, Daniel. Jafet?
Okay, I wanted to respond to that. The question, what is corporate personality? Okay, maybe reminding ourselves on the Solomon versus Solomon case, which specifically established the principle of corporate personality. And this simply speaks to that situation or that principle where a company is held as a legal person, and in this case, therefore, it can sue and be sued on its own name. Other very important elements that come with corporate personality include a company can acquire land, a company can get loans, a company can actually act as a legal person. That is the concept of legal personality, and it's derived from this case of Solomon versus Solomon. Thank you.
Thank you. Thank you. Daniel?
Yeah, it's the personality that, we have juridical, the one that is for us, human beings. Then we have one for corporates. We are making corporates look like, they have legs and ears and they can walk and they can talk. But yeah, I want to agree with that answer. It's the fact that a company can own property just like a human being with personality. A company can enter into agreement in its own particular name, the same way Angelo would enter into an agreement. And a company can sue and be sued in its own name. A company has a common seal. A company enjoys, perpetual succession and everything. A company is like a human being. So yeah, basically, corporate personality is the fact that a company, can, just like a human being, can own property, can enter into agreements in its own name, can sue and be sued, and everything else. Yeah.
Okay. All right. Thank you. Thank you, Daniel. So, and as you do that, remember, most of the time they will ask you about what is the rule in force versus aborto. They will also ask you about the Solomon versus Solomon and another. They can ask you about the indoor management rule. So sometimes you have not had an opportunity to maybe study this at the Kenya School of Law. But of course, the Solomon versus Solomon, when you are studying companies, of course, you study them. Okay? So just be aware that your LLB knowledge will come in handy during oral exams. Okay? Then to add on that, I know I told you to go and look at the definition between the two, the company limited by a guarantee, company limited by shares. Please note that the differences or the distinction is in the characteristics of those companies. So specifically, you can look at Section 7 of the Companies Act, whereby you'll understand that a company limited by guarantee does not have a share capital And then the liability of the members is limited by the company's articles to the amount the member had undertaken or has undertaken to contribute to the assets of the company in the event of its liquidation. Then third, the certificate of incorporation of the company states that it is a company limited by a guarantee. So just go and look at them that way. Thank you, guys. Maybe we can have another person. It is 10:05. Yes, Tum J.
Could you clarify what basically a debenture involves? I tend to have difficulty in understanding it in relation to, I think it's creditors, the secured and unsecured creditors. Could you kindly help in that?
Okay. Lim, are you in corporate?
No, I'm not in corporate, and I want to admit that disturbed me during my time. So I think I'm not in a position to answer that question. It really disturbed me, that question of the venture.
Okay. I know it. When I went for my interview at MMC Asafo, that was one of the questions. I tried my best. I don't know, that is why they did not call me back. I thank God I don't have to deal with the ventures, but if it comes to litigation, we can deal with it. Daniel, please take it away, sir.
Okay. You're funny, man. Anyway, guys, so you see a company has different ways of getting money. Yeah. Okay. And there's so many things that we can talk about. So there are these documents that we usually draft. And sometimes you'll be told that as a security, you'll draft a debenture, or as a security, you're drafting a charge, and this and this and that. And a charge could belong to a human being, or that charge could be held by a company. Yeah. So basically, a company has different ways of getting money. Yeah. Let's say Angelo wants to build high-rise buildings in Karen. Oh, Angelo, that's not allowed. I think Karen, they have to be 2-story at the highest. He wants to build them in Kilimani. Yeah. And Angelo doesn't have enough money to do this. Okay. So Angelo will come, for example, to a bank, let's say DTB, for example, and tells DTB that, oh, I know you are in the business of giving money and making profits out of the amount of money that you have given me. So this is what I will do. This company, my company is called Angelo and Company, for example, or my company is called Salomon Company. Okay. And so I want you to give me 500 million. So what is going to happen is we are going to draft a debenture, and you're going to have a debenture over my company for 500 million. So you are giving me money, and we are registering a debenture. So this debenture will say, in the event that I'm not able to pay you back the 500 million, then we can decide. If it's my bus that I have that is, okay, I have a private jet that is worth, let's say 500 million. Let's say, I know a jet could be more expensive than that. I have a jet that is worth 500 million. So we are going to register a specific debenture. You give me the money, I register your interest over that particular private jet that I have. So in the event that I'm not able to pay you back the money because you have an interest in an asset that my company owes, you can sell this private jet and get back your money. So remember where I started from. A company has different ways of getting money for them to do business, because sometimes you don't have the money, yet you have business to do and you need to do it. So you need money. So the best thing you can do is give people interest in your company. You have so many assets. Tell them that, you know what, I will give you interest over this asset, and you give me 500 million. In the event that I'm not able to pay then you can sell my private jet, then get back your money. If there's any money more than it, you'll give me the excess, but the 500 is yours. Meaning now you have a stake in my company. So Diamond Trust Bank will give you 500 million, but you will register an interest in your company. In fact, your CR12 will show that Diamond Trust Bank has a debenture. A debenture meaning they have an interest over this particular asset that you own as Angelo and Company, for example. So a debenture is what is registered where you get money from someone else, and the agreement is that in the event that you as the company, you're not able to pay back all the money, then whatever debenture is registered will be realized. In what way? Whatever the interest has been registered on will be sold, they will get their money, and whatever remains will be given back to you. So that's what a debenture means. It's a way, it's a tool that companies register or use to be able to get money. Now, a debenture could, so if there's a debenture registered in my company, it means that I got money from somewhere else or someone gave me money, and to protect that person registered their interest over an asset that I own as a company. So in the event that I'm not able to pay them back, then they have the first right to sell that asset, get back their money. If there's an excess, they'll give me the excess. If there's no excess, too bad for me. All that asset is yours. So basically, it's like the asset is theirs, just that it's under the name of the company, but the asset is theirs unless and until I finish paying the money. So a debenture is used as a tool to get money. Now, I was going to the second limb. A debenture can be specific debenture or general and unspecified debenture. So where it's specific, where it is fixed on a particular asset, we are saying that the only thing you can sell Diamond Trust Bank in the event that I do not pay is this specific jet and nothing else. So in the event that you go to my company and realize the jet does not even exist, or the jet was sold, you didn't even know the jet was sold, too bad for you. I'm sorry, you're not secured in my company. If things go wrong, then too bad for you. Then we have a debenture that is general. It's not fixed on anything else. It's a floating debenture. It's floating on anything. So what Diamond Trust Bank is telling me that, yes, I've given you 500 million, but I don't want to say that, I'm registering a debenture over this one particular thing. No, all your assets are mine unless and until you pay me back my money. So if you don't pay me back my money and you are in default, I'll come to your company, and I have, through this debenture that we registered, I will sell everything up to the extent of me getting my 500 million, then leave you alone. Okay, so it could be fixed, meaning we choose a particular asset, or it could be floating, meaning in the event that you've defaulted, it is me to choose. Oh, today I'm selling the chairs, tomorrow I'm selling the TVs, tomorrow I'm selling the private jet, tomorrow I just have to get my money back. I don't care. I just want my money back. Okay, I have to get back that money. So it could be fixed or floating or general. Some people like saying general. Okay. Then you talked about secured and unsecured debtors. Now, if you're giving someone money, for example, if DTB is giving me money, Diamond Trust Bank, they have the right to choose. They have the liberty to choose what they want. So if they decide to give me money, yes, we have a contract that's saying, oh, we've given you this amount of money. You need to pay me back within 12 months. But they have not registered anything against my assets. Then the only thing we have written is that contract and nothing else. So yes, I owe them money, but they're not secured. There's no security in that contract. There's nothing that we chose that in the event that anything goes wrong, then they have to sell this particular, there's no security. So basically they're unsecured debtors. They've given me money. They're unsecured creditors. They've given me money, but there's nothing attached to that money. We just have a contract. But then where DTB is telling you that I'm giving you a letter of offer, and we're saying that the debenture we have over your property, we want a debenture, and that debenture is floating, meaning we can sell whatever we want, we get back our money, then we leave for you what remains. Or that debenture is specific. We will sell the jet, get our money, then leave whatever remains and give you the excess if there is an excess at all. Okay, so when you're talking about secured creditor, it's a creditor who has chosen or who at least has particular assets in that company that are securing the amount of money that they give. But where you have unsecured creditor, this is a person who there's nothing specific. They neither have a floating debenture, they neither have a fixed, they have nothing. There's just a contract, there's just something. Of course, when it comes to money, the law of contract, the law of contract does not say that it has to be in writing. It could even be verbal. I don't know. So long as you have people who can prove it. Yes, you gave me money, so you are a creditor, but you are unsecured. Why? Because you did not choose anything. You didn't pin this money to anything. We did not agree that in the event that I'm not able to pay it, you will sell this or this or this or this or that. So that's the difference. I don't know if that answers the question in the most simplest of ways. If simplest is grammar. That's all I can say, Angela.
Thank you so much. I've understood.
Okay, all right, thank you. So anyone else? Maybe we can take one or two questions, then we give our final remarks and we call it a night.
Angela, I have a question.
Yes.
The class, what's the difference between, I talked about it, what's the difference between a debenture and a charge? What's the difference between a debenture and a charge?
Class, what is the difference between the two? Yes, Japhet, your hand is up. Anyone who can answer, Mwalimu?
Oh, okay. I think, okay, that was an old hand. But anyway, I can make an attempt.
Yes, please.
Yeah, so according to how Mwalimu has explained, just my take home would be a debenture would then mean it's kind of a long term loan, and in this way it's a long term certification or a long term loan, and in this case I may think it's unsecured, and maybe okay, I don't know if I'm really making sense, but a charge on the other hand is just a security for a loan, whereby you promise to pay back a loan, but in that sense you charge your property, or you give out your property as a security for that loan. Thank you.
Okay, thank you for that. Theopilas, okay, please unmute.
So the last time I did a research on this, I found that a debenture is basically the fixed and the floating charge. So it has no difference, such difference.
Okay, thank you for that. Mihango, Stephen.
So just to add on what they have said. So for a debenture, it secures the repayment of a loan, but it is imposed upon all assets of a company. And I tend to agree with my previous speaker. It takes the form of a floating charge, though a debenture can take also a form of a fixed. It can take a form of maybe a charge or now a floating charge. On the other hand, a charge is an interest in land that secures the repayment of money or money's worth. Yeah. So a charge is specifically an interest in land.
Okay, thank you for that. Susan, your hand was up.
Yes, mine is a question. So, how would we differentiate a debenture from MPSR?
Okay, thank you for the question. Now, Mwalimu Daniel.
Yeah, I think the last person explained it correctly. You can't say a debenture is always floating. No, debenture could be specific. When it's specific to a particular property, just that if you look at the Land Act and the definition of a charge is on land. It's an interest on registered on land. A charge is on land. But you see, for a debenture, it could be specific, meaning you could say it's land, or it's a private jet, or it's whatever. But it could be floating, meaning land and everything else that you own. So a debenture can cover both movable assets and immovable. Meaning, if we say it's floating, meaning it means everything the company owns, whether it owns land in Karen, it owns lands or wherever, so long as there's a floating debenture, all those things are securities. But you can't say there's a charge on this company and that charge is a floating. Charge is usually specific you have to define. In fact, there's a place where you define the land. So a charge has to be specific. So, but basically, I think the easiest thing to say, charge is for land, immovable, real estate, immovable property, but a debenture could cover both immovable and movable assets. Okay, so a debenture could be on cars and whatever, but then a charge is for land. Charge is specifically for land. Now, I'll ask another question later on. What's the difference between a charge and a mortgage? I think that one will be easy and we'll be able to answer. Because I'm asking this question because there are questions that usually come up during orals. Maybe someone can be doing the research now. What's the difference between a mortgage and a charge? So yes, the way the last person said, a charge is on land. Debenture could cover both land and movable assets, both immovable and movable. A debenture. Now, there's a question that someone asked about the MPSR, Movable Properties Rights Act. Okay, so MPSR is for movable properties, meaning so for us, what we used to do at the bank is, in the event that someone has given us a car, for example, and we have to make a decision whether, now that the MPSR is now active, and decisions have been made severally, that where you have a movable property, then it's better to register under the MPSR, because now the MPSR covers and deals with movable property. Now, to be safe, you can decide and register a specific debenture over movable properties. You can say, this is a specific debenture for this car. We are giving you the car and there's a specific debenture for that car. So it covers that car. Then again, go ahead and register under the MPSR Act. You can go ahead and register an initial notice over that particular car. So you'll have two documents. You'll have the security agreement, which is under the MPSR, and you'll have the specific debenture. It's because there's a lady who asked that question. Or you can decide and say, you know what, because I know the MPSR Act now is working and it's on, I'll just register a security agreement over that particular car that this person has given me in return for the money. It's a choice that you have to make. But for me, I usually say, just to be safe, why not? Cover the old regime, cover the new regime. Register a security agreement over that particular car that you're getting back as you give out the loan, and register. I mean, what's the harm? There's no problem. If it's double registration, well, the court will cancel one and agree with one. What's the problem anyway? So yeah, the person who has asked, that's the difference. So debenture could cover both movable and immovable. Everything that you own, everything. Charge is specifically for land, immovable property. MPSR, of course, is specifically for movable properties. Now, where you have a movable property, you can decide, do you want to only register a debenture, specific debenture, for example, or do you want to register both a security agreement and also register a specific debenture so that you are covered both ways? If one day someone says, oh, this security agreement, I don't know, this place was not signed correctly. Oh, okay, anyway, I have a specific debenture. Or someone tells you that you go to court and they're like, no, specific debenture, what do you mean? We don't register these things anymore. Then you're like, oh, okay, well, I have cover under MPSR. You can't decide. I mean, it's a choice that you have to make. Again, if you want to go all the way, say, MPSR is there. Me, I'll just register under MPSR. I'll do an initial notice. I'll have a security agreement, and that's it. So it's a choice that you'll make. So yeah, I hope that answers that particular question. But my next question is, what's the difference between a mortgage and a charge? That should be easy.
All right. Okay. Daniel, thank you. We still have 2 hands up. We should be having our last question soon. Japhet, you have a question or you want to answer? Susan.
Okay. I wanted to respond to that question.
Yes, proceed.
Okay, so the difference between a mortgage and a charge, okay, in literary, it's literally put as for a mortgage, there is always a transfer, and it's simply put, take my land until I pay you. That is simply you are transferring your land, while in a charge, there is no transfer. It's simply put as give me the loan, when I fail to pay, take my land. So that's how you differentiate the two. Thank you.
All right. Thank you. That was a good attempt. Susan, your hand was up. That was a good answer, actually, not attempt. Susan?
My response to the same question is similar. So maybe to add, I think for a charge, the definition is given, and or rather the issue of it being a security only is under, I guess, Section 81 or 80 of the Land Act.
Okay. Thank you. Daniel, maybe you can comment.
Yeah, I think that answer is proper.
All right. Thank you. Can we have maybe the last person? And before we have the last person, we have a question in the chat. Someone is saying, when do we use an OS and a notice of motion? Lim, this is something you can take.
Thanks, Angelo. Yes, I am there.
All right.
And OS, I think, let me start with the notice of motion. The notice of motion is just, it's an application, the default application when you want to approach the court on an issue that you want to be handled as a matter of, okay, how can I put it? Before the substantial issues are in the case are handled. So I will say it's an application. The notice of motion is a default application. OS is both it's both a pleading. In some instances, for example, when you are doing there are 2 forms. I think, was it form is it 26 and 27? When you are dealing with the issues of land, and I remember the one on adverse possession or something like that. Yeah, and I think Angelo and Odor will correct me. On adverse possession, I think it was it form 26? I think for form 26, where is it? I think you can correct me on that, Angelo. But OS, that is originating someone, is a pleading. You use it to originate a case. Is it order? I can't remember the order, but it is it order 37 of the civil procedures rules, somewhere
Yes,
there. I
order
think they
that.
can build it on that. Yeah. Angelo, you can add on it. That is what I can say about the two. Yeah.
Yes, uko sawa kabisa kiongozi. Yes, you see, for an OS, you will be told on when to use it. Okay, you cannot just decide and say that the type of pleading that I'm going to use. Okay, it can be an application or it can be a pleading. For example, in the case of, let's say, adverse possession, when you are filing those summons, the originating summons, you are asking the court to determine some questions. You use an OS. Then we have interpleader application. There is an instance whereby you'll be needed to use a chamber summons application, and there is an instance whereby you'll be required to use an originating summon. So what I'm basically saying is the rules will tell you when you will be required to use an originating summons. Okay. Then you see, we were told, and I don't know if Mrs. Mongare repeated it, and I don't know who told you who told you at KSL, Daniel. She was telling us that an OS is like a simple version of a plane. Okay. For example, maybe the matter is not complex or something like that. She told her something to that effect. But I believe nowadays most of the suit are originated by way of a plane. But in specific circumstances, you will be asked to use an originating summon. However, on the other hand, for example, a notice of motion application, it is like a default kind of application. Hata mambo yakiumana, for example, let me say you want to make an application for striking out of a suit or maybe or pleadings, and maybe you don't know what to do Order 1 Rule 14 or what do Order 2 Rule 15 say. I know one of those tell you that you need to use a notice of motion, the other is telling you to use chamber summons. But what if now you want to strike out both parties and pleadings? What do you do? No one is going to kill you for using a notice of motion application. And the lecturers will advise you, if let's say mambo imechemuka kabisa and you don't know what to do, please just use a notice of motion application under Order 51. That is what they normally say. So, but equally on chamber summons, you will be told when to use it. You cannot use chamber summons application on all applications that you want to make. But the specific applications, the rules will show you or will tell you when to use one. For example, in interpleader. Okay. So maybe Daniel, you can comment. We cannot hear you, Daniel. Or can anyone hear him?
No, we can't hear him.
Daniel, we cannot hear you. Perhaps he's experiencing challenges. The one who asked the question, I don't know if you are satisfied.
Yes, thank you.
Can you hear me now?
Yes, we can hear you, sir.
Yeah, so I was just saying there's nothing I'd like to add. I think what you've said is quite clear. For OS, you have to look at Order 36. Only use it if the order allows you to use it. Don't just use it, loosely. Then yeah, for notice of motion, it's always the default. It's always, you always go back. It's what you fall back to all the time when you need to make an application. And I think Angel and Lim have explained that clearly.
Very, very well. Thank you, sir. Now I believe the floor now is ours, unless if anyone else has a question, because we should wrap up. Tumje.
Again, I forgot to seek this clarification. There's this case of Murwatetu, and there's the Mitubel case, which questions normally come around those two cases?
Okay, thank you for that. Your question is a good one because the law is developing really fast, especially on the Murwatetu aspect. And Mutual case, I believe it has settled the aspect of adverse possession, that is in respect to a public property. For example, let's say the land is owned by Kenya Airport Authority. Maybe the certain community have moved to the Kenya Airport Authority land. They have stayed there for the required time. You know, adverse possession, there are elements there. Maybe let's say for 20 years or there or so. So the Supreme Court had settled that matter with respect to adverse possession is with respect to public land owned by maybe the government or its entities. Adverse possession is only in respect to private land. But now where the issue is, it is with respect now to Murwatetu. There is Murwatetu 1, the original one. There is Murwatetu 2. But now there has been applications that have now been adopted by the Court of Appeal. It is really becoming challenging because the first position that was application that was used, I don't have the case that was in the Court of Appeal in Mombasa. That is with respect to death penalty. Is it the death penalty or was it in respect to sexual offenses? But then again to the Court of Appeal in Kisumu, yeah, it is again with respect to death penalty, whereby now they say, Murwatetu say that it is unconstitutional. Then now the Court of Appeal in Mombasa used the same understanding of Murwatetu to tell us that the life imprisonment is unconstitutional. Okay, and then I think that was in Kisumu, and then now it is being reduced to 25, 30 years or 40 years maximum, the aspect of life imprisonment. That thing has not yet reached the court of the Supreme Court. But the other one of the sexual offenses that were held in Mombasa, I don't know, these two Court of Appeal, which one it is, it went to the Supreme Court and the decision came out recently. And the Court of Appeal, I don't know what happened. I don't know if it was emotions. I don't want to be quoted, but they told us that the minimum, let's say, sentence in Sexual Offences Act is not unconstitutional. But the Court of Appeal used their reasoning in Murwatetu case to explain the aspect of sexual offenses, and they arrived to it that the minimum sentences prescribed in Sexual Offences Act is unconstitutional because it interfered with the judge's discretion to prescribe the sentences. But the Supreme Court, juicy, they have said that is not the case. So now expect more from, especially for your oral exams, because they will ask you and maybe your opinion will come in handy. To that extent, maybe I can ask Slim Lim to say something, then Odur, you can come in.
Okay, Angelo, just clarity. You want me to say something on what has been asked about the two cases, or you want me to say my...
Yes. Yes, I believe for the first one, adverse possession was straightforward.
Yeah.
Yes, maybe on the aspect of Murwatetu.
Murwatetu. Yeah, I think what you have said is the position. I don't want to regurgitate what you have said, but I think most of the time, and this is what I remember during our orals, my friend was asked about what was the rationale that informed the decision of Murwatetu 1 when the judges considered the question of the mandatory nature. What was the issue that was in that case that made the judges, decide the way they decided. That was what my friend was asked. And now that if I got your question right, you ask what kind of questions are normally asked when it comes to that case. Now, the issue that my friend fumbled around it, but I mean, the lecturers later clarified to him that the issue that was there was the question of life, the right to life, especially now that one of the accused persons in that decision was expectant, and the court was kind of grappling on how now the unborn child, how they can navigate through that so that they can save the life of that child. And that is how they ended up on the question of that mandatory nature was unconstitutional. So that was the case of those panelists. Now, one thing with the oral is that it depends with the panelists. They can ask you a question, and also it depends on the lack on how you can probably be spot on what they want. What you may answer may not be what those panelists want. They have their own thing that a certain aspect that they want to get from that particular decision. So I think it varies, and it is dependent on the panelists who are there, what kind of question will they ask in relation to a particular precedent that was set by the Supreme Court in this case, the Muratetu one, yeah, something like that. So I think that is what I can say in regards to Muratetu case, especially Muratetu one. Muratetu two was just clarifying to what extent will that decision apply? Is it applicable to all cases, or it was specific, and the Supreme Court was specific that it was only to the murder cases? But again, it will still depend, my thinking though, it will still depend on the panelists that will be there and what is their interest when they are testing on the precedent that was set by Muratetu, as well as Mutubel, which, I mean, Mutubel has rightly been pointed by Angelo, that one has kind of, it is a trite law right now. I think that is what I can say, Angelo, in that regard. Let me leave it there as you hand it to Daniel. Thank you.
Thank you, sir. Daniel?
I think for me, I have nothing more to add. The only thing I can say is there's this case for Joey where he was given, I think, he was sentenced to death sentence. I think it's very important that we understand the rationale of the judge when they made that decision. Because if you look at what was said in Muratetu and what happened there, maybe you'd have questions, but what was her rationale? So I think it would be very important to understand that.
Yes, and I agree. Thank you for that, Daniel. So sometimes the judges will really like to know your views. They would really like to know what you are thinking, or what do you think the judge ruled or held that way, because at that time everything was clear to the judge, the decision of Muratetu. But you see, she had the discretion to either give him the death penalty, which she did, and here we are. So yes, I don't know, Tum, if we have answered you.
Yes, thank you. Maybe to seek a clarification, how many Muratetus are there? I know the one that Maraga decided in 2017. Then I also know the one in 2021 that was clarified by Koome. So may I seek clarification whether there are 3 or there are 2?
In my mind, basically, I don't even know how many they are now. I can even say they are 4, but we can go with 3, especially if the decision that have been made by the Supreme Court, especially the aspect of sexual offenses, they are used because that is time is 2. It was first the reasoning was applied in the Court of Appeal, and then now it became final at the Supreme Court. So that I would say 3. I don't know how many you know, Lim Lim.
I know of 2. Now that you have brought the third one, I think I knew of 2, Murate to 1 and Murate to 2. So now the sexual
Which one was
offenses.
the second one?
The second one was the one that was decided by in 2021 by Koome. Koome was the question was to what extent will Murate to 1 apply in terms of that mandatory nature, and they said it's only applicable on matters to do with murder.
Yes.
That is what Koome said. So that is the one that I know. So that became Murate to 2.
Yes, and then last week, or is it 2 weeks ago, the one on sexual offenses, whereby they said that Moratetu there does not apply, that the Court of Appeal, even they went to the extent of saying that the Court of Appeal did not have jurisdiction or something like that. To maybe raise that question because it was not interrogated in the High Court or something to that effect.
All right.
Yeah, it is a recent decision, specifically on the judge's discretion with respect to sexual offenses under the Sexual Offences Act. That is on sentencing. Tom, is that all right?
Yes, thank you.
Okay. Thank you. I think to that extent we will be concluding. And what I can basically say on my end before I invite Lim Lim, and then Daniel will conclude, is that guys, you have come from far. I know it has been a challenging here, especially in the recent week. Yeah, maandamano. I know all of you are Gen Z, maybe a few. Even some of us now even going to X, because you may log in and then maybe you don't know, you will just see your colleague being beaten up, or those images and whatever that happened in Rongai. So, but we thank God we have made it this far. You have submitted your orals, your project work, and now the Lord is doing its work there, and they will not believe. Then again, the Lord will do its work in the next couple of weeks in your oral exams, and they will not believe. So you guys are ready. Please know, ukiingia kwa hiyo mtihani, you have at least 6-7 marks there, because you will know that content, knowledge, comprehension, and application, that gives you 7 marks. Presentation gives you 7 marks. Etiquette 2 marks. Audibility 2 marks. Composure 2 marks. Okay, so just know you roughly have about 6 or 7 when you step your foot there. Okay, ensure you are dressed properly. Please, I hope you have your suit ready by now, and even from your laundry, and they are in your house. Because if your tailor amekupromise sijui utachukua tomorrow on Sunday, mi naona tu utatumia ile yako yenye uliingia nayo siku ya nini ya orientation, because those people are not trustworthy. They are like lawyers. Okay, lawyers, I don't know, but it depends. We are not that bad. Okay, tuko sawa kidogo. Ama wewe na mrembo yako mwenye ako long distance relationship, huwezi muamini sana, ama boy wako. Okay, so what I am basically saying is, let your things be where you are. Okay, because last minutes are not good. I believe some of you have had an experience already when you were presenting your project work. Maybe someone was to compile work, mnaamuka asubuhi, local man anasema alikuwa maandamano, so hakuweza kucompile kakitu, so now juu alikuwa maandamano, so someone has to translate, okay, such that you are able to print in the morning, to sign in the morning, and maybe to have it uploaded, because I believe you upload it, and you also print hard copies. So the guy was alikuwa maandamano, hajaweza kucompile, ama sijui macho yake tear gas alikula sana, ama hiyo maji ya orange. Okay, so this one, please ensure that you are prepared, because when you are prepared mentally, you are okay. Okay. Number 2, please be at the hall or the waiting area, at least, if not 30 minutes, then let's say quarter. For example, if you are starting at 9, please be in the hall or the waiting area before the roll call is called at 8:30 or 8:45 kama umechelewa sana. And if your orals are at 2 p.m., please be in the hall or waiting area by 1:30. Kama if you are late, then by 1:45. Okay. Because you see, when I was doing my orals, there was this beautiful lady, alikuwa course. She was the first one in our list. I almost karibu niangukie, lakini nikaanguka nayo, so it wasn't that easy. So she came basically like 2 minutes when she was about to be called. She was nervous, she was sweating. Okay, so please be punctual, come very early, it will calm your nerves down. Nilipata everyone amevaa suti ya blue, hata mimi nilikuwa na suti ya blue, it was okay. She did well anyway. So what I'm basically saying, huwezi jua, most of you are online, maybe utatoka na your 10p on that day, so please be smart. Okay, be very, very smart. All right. Thirdly, as I conclude, please remember that what is being tested are your advocacy skills. So even if you don't give the correct answer or whatever, please remember to be composed, okay? Because you understand content knowledge is about 7 marks. But ukienda hapo hivyo unatetemeka, then it becomes an issue. So please relax. No one there wants to fail you. I remember maybe it will be your lucky day. So utapatana hapo na Mong'are, mtacheka cheka, and then pum, uko na 18. Hata yenye ulisoma yote utashindwa, bona nilijua. Okay. So, but if you are ready, you have been reading, so it will give you the confidence to actually stand in front of those committee or those panelists. Sorry. Please don't cry. Okay, even if it looks like you are being purged. Okay. Tafadhali, please don't cry. It is not that bad. And at the same time, remember, you have your project work, you have your bar exam that is out of 60. You are good to go. Okay. You are nervous, just manage. It is only 10 minutes. Okay. Then again, if you don't know the answer to a question, it is best to say that you are not sure. Just be confident. Okay. If you don't know the answer, because I believe in one of our session here, Daniel told us that if you don't know the answer, because imagine someone is telling you to maybe talk to them about maybe correlation between Article 1 and Article 37, or maybe even the decision itself that was rendered in the High Court, specifically on Article 37, and maybe you don't know the decision. You cannot tell me that it called Angelo versus the Honorable Attorney General. Utakuwa umedanganya. So if you don't know, please say that you are not sure. But I can tell you for a fact, if right now you know ni season ya maandamano, so please Google that particular authority on Article 37. Make sure you have read the communication by the acting Attorney General on the ban on nini demonstrations. Ama ile sijui CS alikuwa anasema war is war, was telling us that picketing is not provided for in Article 37. So a lot will go there. So if you don't know the answer, please just say that you are not sure. Just be confident, okay? Just tell them. And if you have an idea, it is better you give that partial answer you want to give. Finally, please maintain eye contact. I'm not saying you look at them in the eye. Sometimes just assume that they are stones, okay? Ama mandazi. If you are afraid to maybe look at them in the eye, there is a way that I do it. Okay, I can pretend that I'm really looking at you, but I am not. Mimi tu niko story yangu, sijui macho nimepeleka wapi. That is if I am nervous. So if they are bread, wewe unaangalia hiyo ni mikate iko na kichwa ya round, na hiyo mwingine ni mandazi ama it is a stone. So just angalia tu hapo hivyo. Okay, so na hapo mambo itakuwa sawa. Engage the panel. That is an interesting question. You know, your question raised this particular issue. Thank you for that question. You know, when I was coming, I was actually thinking about that particular question, and this is what I thought about it. Okay? That this is what I thought about it. Because someone is going to give you a scenario, and then you will have to say something. Okay? Just be engaging. And please don't just go to the house and then to the examination room and you start to introduce yourself. No, please. The preliminary stages are that they will ask for your identification. It will be confirmed. At first, they will actually introduce themselves. I am so and so. Someone will tell you if you know them. After they have introduced themselves, they will now tell you to introduce yourself. So it is not that you go there and start by introducing yourself. Huwezi ingia kwa mtu and then unaanza kuongea. Please be patient and yes. Then don't appear to be overconfident or I know it all. Just be humble. Okay? Just be humble and respectful. Don't hata kama umesoma. Please just show that you are someone that is willing to learn. Don't, because overconfidence sometimes can really distract you. Then in conclusion, dress appropriately. Okay, please usiende na suti ya yellow. My friend from is it not from Eastern ama suti ya green ama kama zile masuti za embarambamba. Okay, please just dull colors are for lawyers. It can be is it gray, not light gray, but the other gray. It can be black, it can be navy blue. Okay, don't dress like a musician kama hizi masuti za kina Diamond surely ama hizi za kina Bahati. No. Okay, tafuta a nice suit, tie mzuri, shati, it can be blue, it can be white. Please usitafute ya yellow ama ya red. Okay, then to our ladies, Donna is not here, but your heels, let them be moderate. I don't even know the inches. Okay, just watu I don't know, ni nyinyi tu ndio mnajua, not the long one yenye inafika sijui nakuwa mrefu sana. So even if you are short, appreciate your height on that material day, and then utaongeza height baadaye. Okay, just reasonable. And then your nails too, please not too bright like greens or red or yellow or something. Just not too long. If you want it to be long, maybe long kidogo. I don't know why they don't like it. Means sijui, because sometimes they are biased. That is all I can say. There is a question in the chat. Maybe Lim, you can answer the question. How do you greet back the panel? And then Daniel will conclude. Thank you.
Yeah, thanks, Angelo. Let me start with the question. How do you greet back the panel? It will depend on how they have the instructions that they have given you. They could tell you most of the times they will introduce themselves, and then they tell you to introduce yourself. Just the same way you have been introducing yourself during the mock orals here. I think the standard is always say your name, say the class, say your registration number, and explain why you are there. Just say that. That is the standard. Your name, your registration number, the class that you are, and why you are there. I think that will not harm you. So I don't know. I want to believe that is. I have addressed that question. The second, the other thing I want to say, in addition to what Senior said, is okay. You have been told so many things about different lecturers. Some even Senior was. He didn't want to mention the name, but he mentioned the class, and I am sure from there you picked who he was referring to. Now, don't go there with those. When you see such a lecturer now, you are like you are doomed or something like that. I remember one of the lecturers that we used to fear in our class was teaching us conveyancing, and people, because he was very erratic, he could get annoyed anytime. This time he's happy. The second, in the next 1 second, he's so mad. So, and people really feared him. But there are guys who went there and the same guy gave them 18, all those kind of things. So don't go there with the notions that you already have, that you have had this lecturer. Just go there and do your best. And your best is this: you have come this far because you are smart. Don't doubt yourself, but at the same time, guard against overconfidence, as Senior said. For me, the experience that I had during the orals was that if you know the specific law and the scenario that you have been given, you are convinced that it relates to that particular legal concept. Start with that legal concept and say, this is an issue that relates to this concept. It makes you capture their imagination. You get their confidence. You give them that first impression, and it is a spark. It worked for me, and I still believe it can work for any person. Go there with the notion that you are going to have a conversation with the panelist. Of course, you'll have a conversation within the law. You are a student of law, so you are going to have a conversation within the law. Usiende outside the law. Yeah, there was a joke. I don't know whether it was a joke that was repeated, that somebody was told, what kind of a person will you prefer to marry? What are the qualities, or something like that? And the person went on citing somebody like Angelo, tall, black, and what? An answer. I think the 3 criteria: tall, black, slim, and something like that. They are not interested in that. They are interested on the legal issue. So have a conversation within the law with decorum, and you will be set. I mean, the criteria that Angela has already given, that is the standard, and you will be all set. And finally, on the question of, it is said that Gen Zs know, they don't know what is called fear. They are confident people.
and you can see, and I'm sure majority of you here, you are Gen Zs. So I don't expect that you will go there and start tensing or something like that. You will be betraying your colleagues. Go there with confidence and give your best. And for those who are not Gen Zs, I think you can, at the moment, everybody claims to be a Gen Z. So I believe you'll go there and do your best. It is doable. Dan did it. McQuay did it. I am here courtesy of the same routine that we have been taken through. And I am sure with God and your preparation, then we shall celebrate together with you when that time comes. Otherwise, I want to wish all of you the very best that God, in his estimation, can give you. Thank you very much. Dan, over to you.
Thank you. Thank you so much, Lim. I think that was beautiful. So thank you so much, Angelo. That was very, very, very well said. Guys, I think for me, I'd start from here. I know you've heard so many stories about orals, but I'd like to tell you a different one. I know a friend of mine who got 19 out of 20 in orals. Guys, that only means one thing: it's possible. It's possible. I'd love it if all of you think about that 19 than thinking about 10, 9, 5, 3, 2, or even 1. Let's all think about that 19 and go for that 19. There's something that Angela said here, and Lim has also reiterated, that is very important. The only reason as to why you have reached here today is because you guys are brilliant people. You are not stupid people. Now, this is not the time to doubt yourself. I know sometimes we are human beings. Fear might come. But every time that comes, I'd like you guys to think about that 19. Think about getting that 9, not 12, not 10, not 9. Think about going for your 19 and nothing else. So my encouragement to you guys is that there's a success story here, and you can write yours on Monday or Tuesday or Wednesday or Thursday. And it's very important to think about writing a success story and not that of failure, because you guys are not failures. You guys are brilliant people. So I'd like you guys to have that mentality, 19 or 18, because it's possible. It's very, very possible. Now, some of the most confident people are not confident because they don't fear at all. They're confident because however much fear they have in their heart, they try their best to be confident. So I know you'll have moments where you feel like, you're fearful. It's the first time ever. You've never done this before. But I'd like you to remind yourself that you are confident people and not fearful people. And so overcome it by thinking about being confident and not succumbing to being a fearful person. So whatever comes, however much it comes, please, I'd like us to think about ourselves as confident people and not fearful people. May that spirit go away from you guys. So it's all possible. Now, one thing that we've been saying here day after day is these guys do not sit down all this while and come there on that day for the sole reason of failing you. No, that's not the reason. Oral exams is not about failing you. No wonder people get 19. They're just going through the system and how the system ought to have been done. At this point, you're supposed to do your oral exams. And that is it. There's nothing else. There's nothing else they're looking for. They just want to know your oral skills. They want to know whether you understand what you've done until now. Now, the law is quite huge. There are so many cases. Sometimes you'll find yourselves in situations where you have no idea of what is happening. This is what worked for me, and I hope it works for you. Sir, I do not know the answer to that particular question, but immediately after this session, I'm going to sit down, do my research, and understand what the answer is. In the event that you are asked a question that you are not very sure of where the answer is, you can always explain, sir or madam, I'm not very sure of what the answer is, but please indulge me. This is my understanding of your question. Guys, it worked for me. I know it will work for you. It has worked for people. And it will. Please don't find yourself saying pass. No. You'll create a different environment with these guys. Don't say pass. You can't say pass. Don't say pass. Just remind yourself, don't say pass. Don't say pass. I do not know the answer to that particular question, but immediately after this session, I'm going to take my time, do my research, and get the answer. I'm not sure about the answer to that particular question. Now, those answers are used in different scenarios. Why you are not sure at all, use this one. I'm not sure of the answer to that particular question, but immediately after this session, I'm going to do my research and understand the answer to that particular question or get the answer. Or where you are not sure of the answer, but you have an opinion. Sir, I'm not sure of the answer to that particular question, but indulge me. Here is my understanding or my opinion of the matter. Please. What lecturers want to know is, if you are before the Supreme Court, for example, and someone asks you about that particular case that Angela was talking about Article 37 and 1, what will you do? Will you freeze and say, pass? Or will you freeze and say, I have nothing? You, as an advocate representing the President of the Republic of Kenya, what would you do in that scenario? So please, just try, think on your feet. If you're not able to think, please, you can use the answers that I've given you. Please, just try. Just try. Just ensure that when you leave there, you have left everything in that room, everything you had, you've left it in that group, in that room. The reason why orals are very important is, imagine if you get 19, it's 19 all through, 19 in probate, 19 in legal writing, 19 in, you have 19 all through, and that's such a boost. I can promise you guys, it's such a boost. So leave everything in that room. If this is the time for you to lie to yourself that you're a confident person, this is that time. Guys, in the future, you are going to be the judges of this country. You are going to be in the city, sitting in the Supreme Court. You're the ones who are going to make decisions in this country. You are the future senior counsels of this country. That is who you are and nothing else. So please try your best and focus on that. If you haven't read much, try your best. At least try and know something. Try and know something. It gives you confidence. It boosts your confidence when you know something. Try your best and know something. One last thing I can say is, guys, it's possible, it's doable. Think about winning and not about losing. If you convince your mind that you are going to lose, then you lose even if you are supposed to win. If you convince your mind that you can do it, then you can do it, even if it was tough and very hard to do it. You just need to convince your mind. So I'd like us to think about that 19. I'd like us to think about that success story and nothing else. Nothing else, guys, because you can do it. That is all I can say. I wish you guys all the very best. I'm waiting for next year when you guys will be texting me and asking me if you can join the assemblage so that we continue doing this good work together, all of us. The main intention is to ensure that we lower these anxieties, that we mentor each other, that we grow as a profession, that we give back to each and every person that we are able to give back to, because that is who we are. And as you do that, may the Lord bless each and every one of you. After this session, I know this is our last session for orals, we will plan ourselves, sit here with you again, revise those papers, do our best with you. And I know and I believe. And all these guys, please, we're doing it as friends. Let's just do it as friends. And that's why I keep saying, when you're here, be free, speak to us, ask us that particular question that you have. Whatever is in your heart, let us know. Even on the day for orals, please, you can text me, text Angela. Oh, I'm feeling like this, man. What do you think? Angela will tell you, be confident. It's possible. You can do it. If he has time, he can call you and talk to you and encourage you. We are here for you. We want to work with you, and that is what we want to do. So all the best. See you guys after orals. We will have sessions for revising the past papers, and I believe and I know that they are going to be very good and very resourceful and very helpful to you. Please text me, text Angela or whoever when you need to consult on something or you need encouragement or you need anything. We are here for you. We are here to hold your hands, and it is possible. We're not holding your hands because we think you're going to fail. We are holding your hands because we know that you are winners and nothing else. That is all I can say, and I'll finish off with a word of prayer. Our Father, what in heaven, Lord God, we thank you. Lord, we worship you and we adore you. We thank you for these students. We thank you for the institution that they're going through, King Jesus, our God. We ask that may you give them grace. May you take over their minds, oh God. May you convince them and help them to know that they can do it, that they are winners and not losers, that this is also possible, that this is just part of life, oh God, my Father, King of Kings. May you be with them even as they sleep this night, oh God. May you give them peace. For those who are having their exams on Monday, King Jesus, oh God, my Father, may you give them good rest, oh God. May you open their minds. May you, King of Kings, my Father, never, oh God, reignite their memories, oh God. May you help them to remember. May you give them confidence, King Jesus, oh God. May they trust in you, King of Kings, Lord. Lord, we thank you. We worship you. We surrender all to you, King of Kings, only you alone. We thank you. We bless your name. We worship you and we adore you. It is in your mighty name that we pray and believe. Amen. Thank you, guys. I'll share the recording. And may God bless each and every one of you. Bye. All the best, guys. All the very, very best.
Bye-bye. All
Thank
the best,
you.
guys.
Bye.
Good night.
Good night.